everyone. Thank you so much for joining our webinar. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Matt Herstein, a Michigan construction lien law expert. Today's webinar topic is a contractors, subcontractors, and suppliers step-by-step guide to getting paid. So without further ado, I would like to introduce the fabulous Matt Herstein.
Well, thank you very much, Jessie. I appreciate the kind words. And I'm here today to talk to everyone about Michigan construction lien law and contractors, suppliers, and subcontractors guide to getting paid. So there's a process for that, not surprisingly, and we have some slides that we can go through and kind of guide everyone along in terms of what it is that we're going to be talking about. And if you could show the first slide, it'll kind of give us an overview of what it is that we're looking at. And here we go. So our agenda today, we're talking about the importance of having a written contract, and that's where it all starts. Having a contract is kind of key to everything that you're going to do, and the better your contract, the better position you put yourself in. And then we'll talk about some liens, your lien rights, bond rights, and then some waivers, and the importance of how you do that process. So with regard to having a written contract, one of the things that that's going to do is it's going to help you avoid disputes. The main things in your contract are going to be who are the parties, of course, and then it's going to be the scope of work that you're going to be presenting and providing to an owner or a client. And then it's going to talk about the price you're going to get paid. And these are often the biggest points of a dispute. What is the scope of work and how much is the contractor going to get paid? You want to have a clear mechanism in your contract for what's going to happen if it's outside of that scope. That's usually where the issues come up. The owner wants something. If your contract is clear, if it identifies properly what the scope is, then you're in a better position to know, okay, this is something that if the owner wants, it's going to cost the owner extra. And then hopefully your contract will also talk about the process for change orders, things like that, where if you are going to do extra work, how much are you going to get paid? The better you can keep open your lines of communication, the better you can document things along the way, the less likelihood of having a dispute with an owner, and the greater the likelihood that you're going to get paid the right amount for the work that you're going to do. Your contract can also outline what's going to happen in the event of a dispute. Are you going to go to arbitration? Are you going to go to litigation? Things of that nature can be important for a contractor. Arbitration, I find in Michigan, I prefer it to court. It's usually a more expedient procedure, but you only get to go to arbitration if the parties are going to agree on it. And a lot of owners may be leery of arbitration. They might not know what it's about. So it's a nice thing to put in your contracts if you can. And then on residential projects, a contract might help you preserve your lien rights. If you are going to work on a residence in Michigan and you're going to do more than $600 worth of work on that residence, your contract should be one, in writing, and two, it should also list your residential builder's license number. And if you don't have a contract that's in writing on a residential project that lists your builder's license number, then you can set yourself up for some problems in terms of your ability to record a lien or even to collect any of the amounts that you might be owed. And so if we look at the next slide then, securing your lien rights here. And one of the things that's really important to do as a contractor is to preserve those lien rights. Again, that starts with the contract that you have. So hopefully you have a written contract if you're going to be doing residential work. But even if it's on a non-residential project, you could have lien rights. Now there's two types of projects. One is a private project and the other is a public project. So public projects are going to be for government entities, municipalities, things like that. Private's going to be for a corporation. That's going to be for a residential structure. And there is a difference because you can't record a claim of lien against public property. So if you're working on a private project, you're going to want to, again, have a contract. And then when you start the work, you're going to want to ask for what's called a notice of commencement. That notice of commencement is going to be a document that should be recorded, and the notice of commencement will basically list who's doing work on the project and what is the legal description for that property. The legal description is important because that's how things get recorded with the Register of Deeds. And once you know the legal description, you can send out a notice of furnishing. Notice of furnishing is something you're going to want to send out right away. Within your first 20 days of doing work on a project, you want to get that out. That's a document that goes to an owner, it goes to the general contractor, and it basically says, I'm going to be providing labor or materials on this project. And if you get out a notice of furnishing, it lets everyone know that you're a party here who needs to get paid. Notices of furnishing then tie into sworn statements. Sworn statements are something that is going to be presented on a construction project, and it's usually something that a contractor will provide to an owner, and that's going to list everybody who's doing work on the project. So if you sent out a notice of furnishing to a general contractor, say you were a subcontractor, and then the owner gets a sworn statement from the general contractor and it doesn't list you, then they're going to notice that because they should have the notice of furnishing, and then they should have the sworn statement, and they should have a notice of furnishing from everyone on that sworn statement. And if the owner sees that they have a sworn statement that doesn't list a party that provided a notice of furnishing, then they can talk to the general contractor, find out what's going on, hopefully get everything corrected, and make sure that you're getting paid. Now, when the sworn statements are provided, the general contractor should be providing lien waivers, and this is true for subcontractors as well, who are asked to provide sworn statements and lien waivers. And the lien waivers are going to be an indication of amounts that got paid. So everything should match together. Your sworn statement should have listed all of the contractors who are being paid, and then those parties can provide lien waivers. Now, if things don't go right, you have the right as a contractor who's providing labor and materials to record a claim of lien. And that has to be recorded within 90 days of your last day of work. And what that is going to do is it's going to allow you to start a foreclosure process and sell the property if you're not getting paid. So that's one of a contractor's most powerful tools for getting paid. And if we look at the next slide, we're talking about here construction liens. And again, it's very important to record them within the last 90 days, or within 90 days of your last day of work. The courts have construed that particular provision very strictly. So if you record a claim of lien 91 days after your last day of work, it's too late. Once you record a claim of lien, you have to serve it on the property owner, and you have to serve that lien within 15 days of the day that it's recorded. And this is kind of the first steps to foreclosing on that property. What's going to happen is if you remain unpaid, the construction lien allows you to sell the property that's subject to your claim of lien. And because you can now force the sale of someone's property, there's an increased likelihood that that person is going to, come to the table and step up and make any payments that are properly owed. So preserving your construction lien rights are extremely important, and it really can be a contractor's most powerful tool for trying to collect work. And if we look at the next slide, securing your bond rights. So not every project is going to have a bond. Bonds kind of take the place of construction liens. Oftentimes you'll see bonds on public projects, and there are some statutes that provide for the provision of bonds when you have a contract that's in excess of $50,000 with a municipality or public owner. The purpose of the bond is because I mentioned earlier, you can't lien a public building. So a bond kind of steps in there, and it's a way to guarantee payments to contractors who are providing labor and materials. So a bond is issued by a company called a surety, and the surety has got to be an entity that has a significant amount of assets, and the surety will essentially promise to make payments that are properly owed to contractors providing labor and materials. Now, in order to preserve your bond rights, again, it starts with providing a notice of furnishing. You want to do it again within the first 20 days of furnishing labor and materials. And that notice of furnishing should usually go to the surety who's issuing the bond, the contractor that you're working for, and the owner. If you're a general contractor, you might just have to send it, well, if you're the general contractor, you have a contract with the owner and you don't have to provide a notice of furnishing. But anyone under the general contractor needs to make sure they get that out within the first 20 days of providing their labor and materials. Once you've notified the surety, the owner, and any above you contractors, then you've completed the first steps. And then as you go along, you're hopefully getting paid. But in the event that you're not, you're going to prepare what's called a notice of bond claim. And that notice of bond claim is going to be something that you're going to send, again, to the surety, the owner, and the contractor. And you're going to indicate whatever information that they're ultimately going to request. But initially, you're going to indicate the amount that you're owed for work on this project. The surety will inevitably have questions for you. They'll want to know your total contract amounts, how much you've been paid to date, various things like that. But you just need to start by making sure the surety gets notice of the dollars that you're owed. It's important to send a bond claim notice timely so that the surety can't have a reason for rejecting it. And oftentimes, 90 days within your last day of work is going to be a prerequisite for making your bond claim. Now, because bonds are slightly different than construction liens, it can be a different process, and they can extend the time periods. So it's possible that you have more time to do a bond claim than a lien claim. You're going to have to take a careful look at any bonds that are issued to see if they extend those dates. But better safe than sorry, and it's best to try and do that within 90 days of your last day of work so that you don't have a time bar to your claim. Next slide. So payment bond claims, again, it's in lieu of a claim of lien, but not always. You may have a case where you have a private project where there are construction lien rights, and in addition, you have a bond claim that you might be able to make. Now that's going to happen usually on a larger project where you have an owner who's working on maybe a multi-million-dollar project, and they want to make sure that the contractor is going to pay people so that there aren't liens recorded against the project. And if you do have a bond, it doesn't mean that you won't be able to record a claim of lien. You may have two alternate ways to recover money in both a payment bond claim and a claim of lien. Now, there are some types of bonds that could come out that are to discharge your claim of lien, but that's a separate issue altogether. If you make a bond claim and the surety and the contractor and anyone else who owes the money doesn't pay, then you can file a complaint against the surety that issued that bond, and the surety is supposed to make payment in the event that you prevail on your claim. So if you were to go to court and you were to get a judgment against the surety, that surety is almost always going to have sufficient assets to be able to pay your claim. So having a bond claim or having a lien claim are both very good ways for a contractor to try and ensure payment when you have someone at the end of the line who's going to be collectible, or a property that you can foreclose against to try and recover the amounts that you're owed. Okay, and then when it comes time to exchanging a release for payment for a check or something like that, this can be tricky. It really shouldn't be, but sometimes people like to play with the rules a little bit. There are different types of waivers of lien that can be requested and that you can be asked to provide. Some of these are called partial waivers of lien. The partial waivers of lien are something that you're going to provide in exchange for a partial payment. And then there's a full waiver of lien. And the full waiver of lien should never be provided unless you're getting paid in full. Now, there's also two different types of both partial and full waivers of lien, and these are called conditional waivers. So you have two different types of waivers, conditional and unconditional waiver. A conditional waiver of lien is one that says, I'm giving this lien and it's conditioned upon my receipt of payment from you. An unconditional waiver of lien has no such condition attached. So it's basically saying, I'm waiving my lien unconditionally. Now, you can do a partial conditional or a partial unconditional waiver, and you can do a conditional full waiver and an unconditional full waiver. The ideal when it comes time to exchange a waiver for a check would be to provide a conditional waiver of lien to whoever's supposed to pay you. And let's say you were owed $10,000. You provide a conditional waiver of lien for the $10,000. And then when you receive payment for that $10,000, then you provide an unconditional waiver of lien for the $10,000 check that you received. Sometimes you'll have someone who refuses to accept just the conditional waiver and they insist upon an unconditional waiver. It's never a good idea to give the unconditional waivers in advance of payment. If you are dealing with a situation where someone is forcing you to provide an unconditional waiver in exchange for a check, it's best to do it contemporaneously rather than provide it in advance. And if that's still not working, you could send an email or something like that enclosing the unconditional waiver and include some language on it that says, I'm providing this unconditional waiver per your request in exchange for the promised payment of a certain dollar amount, whatever it is. That's not the ideal way to do it, but it's keeping a written record of why you're providing an unconditional waiver in advance of a certain payment. And I have yet to encounter a judge who received an unconditional waiver of lien, which was provided on the promise of a payment, and then refused to let the contractor enforce its right to payment when it didn't get the check that was promised for the unconditional waiver. Again, it's not the ideal situation to do that. I wouldn't recommend providing an unconditional waiver in advance of payment, but there are certainly some circumstances that come up and a contractor just makes a decision to provide the unconditional waiver in exchange for a promise of payment. And usually the courts are going to be pretty sympathetic in those scenarios. So,
all right, so I think we've kind of come to the end of your presentation, Matt. We are going to take a couple of questions now. That was really great information. Thank you so much for going over all of that with us. I really do appreciate it. We do have a couple of questions that have come through.
sure.
And you were kind of talking about the lien waivers and releases just a moment ago on the last slide. And it says, does Michigan have a standard form for a lien waiver?
Yes, the Michigan Construction Lien Act, which is basically the statutes that govern construction lien rights, do have sample forms for things like sworn statements and waivers, and there are standardized type forms for those documents that can be put together. My office has, standard forms that are based upon the Michigan Construction Lien Act. If somebody can't find them. And they really shouldn't be very complicated. There are a lot of owners who are going to try and put all sorts of waiver language and things in their waivers, but a proper waiver form is actually very simplistic, and they can be found if you look at the Michigan Construction Lien Act.
Wonderful. Does a contractor or a supplier have to use that standard form, or can they use one that has their own language on it?
You can typically do whatever the parties agree to. So, the default is kind of the standard form based on the language in the Michigan Construction Lien Act, but parties can agree to do anything, and there's no requirement that your lien has to look a certain way. I'm sorry, your waiver has to look a certain way. So you can play around with the language, but if you do it too much and you deviate too much from what I would consider a typical standard form, somebody may find the waiver objectionable in some way or another, and it might not have the desired effect.
Okay, amazing. Thank you. You kind of touched on this at the beginning of the presentation, and another question that came through, it says, do I have to have a written contract? And do you have to be a licensed contractor to have lien rights?
So it depends on what you're doing, whether or not you have lien rights or not. Most contractors will have lien rights under the Michigan Construction Lien Act. Do you need a written contract? No, you don't need a written contract, but it is a good idea to have one. Now, if you're doing residential construction, you may need to have one in order to preserve some of your rights. So if you're, for example, going to be building a new house for a couple, and it's a residential home, single family, you're going to need a written contract in order to protect yourself in the event that that couple decides that they don't want to pay you for some reason or another. And you do have to be licensed to perform most residential related construction work. There are a few exceptions, but I would recommend to anyone who's going to be doing residential construction to get licensed.
Perfect. Thank you so much for that clarification. And then another question that has come through, it says, if multiple companies file a lien against the same property, which lien takes priority on getting paid?
So interestingly, construction liens are given the same priority with one another, even when they're recorded one later than another. The construction lien rights are going to be tied together, and so you may have to end up splitting fees on or amounts that are owed on a pro rata type basis. Another interesting thing that's going to interfere with your ability to pay is other interests against that property. So maybe a mortgage, and then it is going to matter. Things like your first day of work on that project are going to come into play, when the construction started to work on a project, because the mortgage holder is going to have rights against that property too. And if the construction work starts before the mortgage was recorded, then the contractors are going to be in a better position, because then they'll be priority. But if you have, say, a general contractor and a subcontractor recording two liens against the same property, the owner is only going to have to pay once for the applicable materials. So if the general contractor ends up getting paid, the subcontractor doesn't get paid a duplicate amount. That's going to even itself all up at the end.
Okay, wonderful. Another question that came through is, can attorney's fees and filing fees be included in my lien amount?
So the Construction Lien Act provides the ability to recover attorney fees, and there is some case law that really says that that's not going to be part of your lien amount, but it is something that you can recover. So if you were to record a claim of lien, you don't want to include the attorney fees that you might be seeking as part of the actual lien amount. You want to preserve those rights and claim those attorney fees on top of the lien right, or on top of the lien amount. So if you're owed $100,000 and you say you have $5,000 in attorney fees that you've incurred, you want to keep your lien at the amount of the actual construction improvements, and then if you have to foreclose, add on those attorney fee amounts under the Construction Lien Act.
Wonderful. Yep, that's the way we see it go as well. And then the last question that I think has come through, it says, how long is my lien effective?
So there is a time period in which you have to start that foreclosure process, and that's going to be 1 year from the date that the lien was recorded. So if you record the lien, say May 30th, then you want to start your foreclosure action within 1 year of that date. And if you wait longer than that, you've lost the right to foreclose on the property based on your claim of lien. And at that point, if it's been more than a year, the owner can actually file an affidavit with the Register of Deeds and look to have your lien removed.
Okay, well, good to know. Make sure you guys are paying attention to your dates and what deadlines you guys have to fall into. All right, I think that's all the questions that have come through so far. If you do have a question that wasn't addressed, please feel free to reach out to me. I'll be sure to answer any questions that I can, and we will make sure that Matt is helping us out if we're not able to answer that question out for you. All right, so we're going to go to the next slide here. All right, so who is ready to win a gift? We are going to be testing your knowledge. So if you think you can answer these questions, go ahead and do so in the chat, and we'll send you guys out a little prize. Here are some of the questions. When is the deadline to file a notice of furnishing and request pardon me, for a notice of commencement in Michigan for subcontractors and suppliers on residential or commercial projects? And then the other question is, when is the deadline to file an affidavit of mechanics lien in Michigan? So if you know those answers, go ahead and chime in. I would love to send you guys over a little gift. All right, so here are some of the SunRay's resources that we have available to you. You can scan that QR code, gain access to all sorts of things that will help you guys stay organized, know your deadlines, and secure your lien rights. There's deadline calculators, project information sheets. We even have a state lien law chart on there that you can click if you're working in a neighboring state. Remember, every state has their own set of lien laws and deadlines and what type of documents are required. So make sure you're checking it out. See what's required for each of those states if you're not working in the state of Michigan particularly. All right. The next thing that we have for you, we have a new service here at SunRay. We're going to be doing SunRay collections, so we can help you with all your collections. So if you're running out of options, you're still not getting paid, you can reach out to us. We will be able to see if we can help you out and get you your money that's owed to you guys. All right, let's see. All right, the next webinar that we have with Matt is going to be Don't Sign a Release Unless It Says This One Thing. That's going to be Thursday, August 22nd at 12:30 p.m. Eastern. So go ahead and sign up for free at sunraynotice.com/education. We'd love to see you guys there. All right. If you guys don't mind, take a moment to scan this QR code, give us some feedback about today's webinar. We'd love to get your feedback so we can always improve. And it also helps to get this information out to other contractors and suppliers like yourself. With that is all we have for you guys today. Thank you so much for everybody that attended. We hope to see you guys at our next webinar. Thank you again, Matt, for everything and for answering all these questions. You were amazing. I hope you all have a wonderful and beautiful sunny day. Thanks again, everyone. Bye-bye.